going to explain about issues of this problem question. So in these cases, the issues is whether Daniel, a financial advisor, has breached the contract to his action, and whether Moni can claim her right as a victim of Daniel's fraud. So next for the rules, in accordance with section 61 of the Contract Act of 1950, undue influence, when the relationship that exists between the parties are such that one of the parties is in a position to dominate the will of the other and utilize that position to acquire an unfair advantage over the other, the contract is said to have been induced by undue influence. So, in the other hand, according to the Section 62 of the Contract Act of 1950, it identifies potential situations wherein one party is deemed to be in a position to dominate the will of another as follows. First, where he holds a real or apparent authority over the other. Second, where he stands in a fiduciary relation to the other. Or third, where he made a contract with a person whose mental capacity is temporarily or permanently affected by reason of age, illness, or mental or bodily distress. So for the last section, for undue influence, under the Contract Act 1950, Section 63A states that the burden of proving that the contract was not induced by undue influence shall lie upon the person in a position to dominate the will of the other, where a person who is in a position to dominate the will of another enters into a contract with him, and the transaction appears on the face of it or on the evidence adduced to be unconscionable.
Based on Section 70, Contract Act 1950 includes certain acts which are committed with intent to induce another party to enter into a contract. The section lists 5 different acts which may constitute fraud, which are as follows. Firstly, the suggestion as to a fact of that which is not true by one who does not believe it to be true. Secondly, the active concealment, which is hiding of a fact by one having knowledge or belief of the fact. And thirdly, a promise made without any intention to performing it. Fourthly, any other act fitted to the deceived. And lastly, any such act or omission as the law specially declares to fraudulent.
As a general rule, it may be stated that whenever a person causes another person to act on a false representation, which the maker himself does not believe to be true, he is said to have committed a fraud. However, the general rule is that mere silence or non-disclosure will not constitute fraud. There may be certain circumstances under which silence or non-disclosure may constitute fraud. The exception as follows. Firstly, situation where it is the duty of the person keeping silent to speak. Secondly, in circumstances where silence may be equivalent to speech. And thirdly, situation where such duty to speak arises as in contract Uberime Fide, which is it is based on utmost good faith. In contract of this nature, such as involving insurance, there is a duty to disclose all material facts.
Cases for undue influence. In the case of Dato' Jaginda Singh versus Tara Rajaratnam, the respondent was misled by her brother-in-law into generating her land as security for his loan. Later, the appellant visited her home, persuaded her to sign a several documents under the false pretenses, in the act transferring her land without her knowledge. The land was then sold to a development company divided into 70 lots and sold to a various buyer. The respondent filed a lawsuit alleging fraud. The court ruled in her favor, finding the appellant guilty of the fraud and avoiding her damage. However, the court decided to subsequent buyers' title not to be revoked as they are bona fide persons protected under Section 343. In the case Chesombit Yi and Mahapit Lead 1989, the third plaintiff suffering for a mental incapacity was unduly influenced by her brother to sign a mortgage securing a loan for their company. The Singapore High Court found that the bank were complicit in undue influence exerted by her brother and set aside the mortgage. The court clarified that while a sibling relationship alone don't presume undue influence, and the fact demonstrated it persists in this case, the court highlighted that the burden of proof lies with the donor to assure the transaction was appropriated.
Case under Section 17, fraud. In the case of Weber versus Brown, the plaintiff respondent sued the defendant appellant for damages based on an alleged false and fraudulent misrepresentation about the number of rubber trees on an estate over which the latter had the right to purchase, which he transferred to the former valuable consideration. The number of trees portrayed exceeded the real amount on the land. The Court of Appeal concurred with the lower court conclusion that the defendant appellant had made the claim misrepresentation falsely and fraudulently, causing the plaintiff respondent to obtain and then exercise the right of purchase. In the case of Senanayak versus Enio, the plaintiff bought shares from the defendant's firms because she relies on the defendant's statement that the firm was a good and potential firm. Plaintiff claimed reimbursement for money spent for shares of the defendant's interest in a business that she later liquidated due to a deception that encouraged her to purchase the shares. PC permitted rescission because the plaintiff did not affirm the contract by convening and attending a partner meeting while being aware of the firm's precarious financial situation. PC further stated that plaintiff was entitled to make all inquiries and to endeavor to learn all of the facts, which would have led to her affirmation of the contract but had not done so.
Next is application, undue influence. Number 1 is subsidy relationship that show the relationship between Murni and Daniel can be is as fiduciary one to those specifically mentioned in section 16.2. Given this relationship that the law pressure undue influence unless Daniel can prove otherwise. Number 2 is unfair advantage has shown that Daniel used his position to persuade Murni to invest, obtaining an unfair advantage for Murni. Murni is a retired who is not highly knowledgeable about finance, so Daniel easily advised the pure with gentle persuasion and advice. Number 3 is domination. Daniel holds a position of trust of authority over her due to their long-standing relationship and his role as her advisor. It is because Murni has a retired woman living alone and did not know much about their finance. Next is fraud. Number 1 is false representation. Daniel suggests that the investment proposal was a low risk opportunity with granted returns, knowing that this was not true at the very least without a reasonable basis for believing it true. Number 2 is active concealment. Daniel actively concealed crucial information by not disclosing the full extent of the risk involved in the investment. This mission prevent Murni from making an informed decision. The contract can be cancelled due to meeting the condition. The conclusion: Daniel is a financial advisor was broken the law with his action, and Murni can claim his right under section 16 and 18 as a victim of Daniel's manipulation. The decision in the case of Murni and Daniel declared the contract null and void because it met the criteria. Murni can also request cancellation and claim possible damage.